Vice Chair Commissioner Butler, can I get a thumbs up if you can hear me? Great. Good morning. We're on the record in case number 2020-00244, electronic application of Caldwell Solar, LLC for a certificate of construction for an approximately 200 megawatt merchant electric solar generating facility in Caldwell County, Kentucky. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission and also serve as chairman of the Kentucky State Board on Electric Generation and Transmission Siting. I'll be presiding over today's hearing. Joining me today via video conferencing are the other siting board members. The other siting board members in this matter are Amy Cubbage, Vice Chair of the Kentucky Public Service Commission, Mary Ann Butler, Commissioner of the Public Service Commission, John Lyons, Deputy Secretary of the Energy and Environment Cabinet as proxy for Cabinet Secretary Rebecca Goodman, Cindy Montgomery serving as proxy for Interim Secretary Larry Hayes, and Larry Curling and Gail Cherry as the local ad hoc appointees. At this time, I would caution attendees to please set your cellular phones to silent. I'd also ask that you do the following given the virtual nature of this hearing. Mute your microphone if you are not speaking. Attorneys, when interjecting, please state your name so the video record is clear. If you use a phone for audio and a computer for video, please turn off the computer's audio. If you're in a room with several people on their own computers, please leave the audio off but for one computer. If another participant is in a nearby office, close doors between the offices. Use wired headphones or earbuds in lieu of wireless. Keep a charger nearby in case your battery runs low. And finally, most importantly, please, if you are at any time experiencing technology failure, please notify PSC staff at the previously provided contact information so that we can stop the hearing and get everything back on. The hearing today is for the purpose of taking evidence in case number 2020-244. At this time, we'll have the interior of appearance of counsel, given the unique challenges of doing this hearing remotely or virtually. I would also request that counsel also introduce their witnesses upon providing their entry of appearance. For the applicant.
Morning, Mr. Chairman. Can you hear me all right?
We can.
Great. Thank you. Mr. Chairman, members of the board, my name is Jason Bentley with Ngr LLC. I have with me Ms. Katie Eckert, also with Ngr. We have two primary witnesses this morning, Mr. Chairman, but as you can see, we have a number of experts waiting in the wings. I believe I spoke with board counsel yesterday about our witnesses, but if you'd like, I can go ahead and introduce our two primary witnesses and then also let you know who the experts are waiting in the wings in case we want to get further into the weeds on any subject matter.
That'd be fine.
So our principal witness, first one will be Courtney Pelicero with National Grid Renewables. She is a permitting specialist and primarily responsible for this application. She will speak generally to the application, environmental impact and studies, project facilities and layout, mitigation measures, decommissioning, public information meetings and notices, high-level noise, glare, road construction, operations impacts, and pretty much anything not having to do with financing, transmission, landowners, public outreach of the public information meetings, of which our second witness, Ellie DeVleek, will also be able to speak to. Ellie is also with National Grid Renewables. Her title is developer and has been the developer for this Caldwell project. She can speak generally to the economic impact, taxes, any local industrial revenue bond issues, transmission, electric grid studies with MISO and BREC, landowner relations and leases, public outreach, and the public information meetings. Those will be the two primary witnesses. We'll introduce Courtney first, but beyond that, the experts that we have available today, Bruce Moreira with Cardno, who's the environmental project scientist, who can speak to the site assessment report and various figures. Yosef Shirazi with Cardno is a project economist who can speak to the economics and modeling that was done. David Hessler with Hessler Associates, Inc. He is the noise expert. Benjamin Taylor with Terracon performed the car studies. Andrew Lyons with Cohn Resnick is the property specialist and did the property valuation studies. Michael Morris with National Grid Renewables is this Director of Energy Assessment and Project Planning, who will speak to the glare studies that were performed. Brian Zeller is also on the, here with us today at the meeting with Frost Brown Todd. He's the tax attorney and can speak to local taxation issues. And then also finally we have Emmanuel Hiley with National Grid Renewables, who's the construction senior project manager and can speak to construction matters.
Okay. Thank you, Mr. Bentley. For commission staff?
Linda
Yes, sorry,
Gosnell.
Mr. Chairman.
Mr. Chairman, I'm sorry.
I'm sorry. I wanted to point out, this is Katie Younger. I'm also counsel for Caldwell Solar. I'm literally a backbencher today at the hearing, but I did want to know my presence for the record.
All right.
Sorry.
Thank you, Ms. Junker. For council?
Linda Gosnell.
All right. So it's my understanding, I reviewed the website that, that on the 16th, Caldwell County provided proof of publication of the hearing. Is that correct?
Yes.
Okay. All right. And other than outstanding motions for confidentiality, Mr. Bentley, Ms. Eckert, is there anything that we need to take under consideration before we call the first witness?
Mr. Chairman, we still have a request for deviation that's outstanding. I know you all been addressing some of those in the final orders, but that's the other outstanding matter in this case.
You mean your request for the deviation for the statutory setback?
Correct.
Okay. All right. Nothing else. Ms. Eckert, Mr. Bentley, you can call your first witness.
Thank you, Mr. Chairman. We'd like to call as our first witness Ms. Courtney Pelicero. Courtney, can you please state your name and title for the record? Ms. Pelicero, we don't have audio for you.
I got you, Ken. I got you.
No.
Hello, can you hear me now?
You can.
There
So,
you go. Yes,
Ms.
we can hear you now.
Ms. Pelicero, do you mind to raise your right hand?
Now she can't hear us, perhaps.
Can you hear us, Ms. Pelicero?
Hello, can you hear me now?
We can hear you. Can you hear us?
Yes, I can.
Okay, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Okay. Mr. Bentley, you can ask.
Ms. Pelicero, would you please state your name and title for the record?
Yes, my name is Courtney Pelicero. I'm a permitting specialist with National Grid Renewables.
And are you the person responsible for the preparation of this application?
Yes, I am.
With that, Mr. Chairman, we don't have any questions. We'd like to tender the witness for cross-examination.
Okay. Ms. Gosnell, do you have any questions?
I only have a few. There were extensive data requests in this case, so I only have a few questions. The first relates so that I can be clear on your times of work for the purpose of the record. You've mentioned 7 days a week from 6 a.m. to 10 p.m. for what I call non-noise making activities, by which I mean no pile driving and no operation of heavy equipment. Is that still the plan that you're proposing?
Yes, that is accurate. 6 to 10 for the non-noise producing activities and 7 to 7 for other noise construction activities producing noise like pile driving and loud machinery.
And so on the 7 a.m. to 7 p.m., which would be the noisy construction activity, you've proposed a makeup day on Sunday. Is that a makeup day to allow for weather delays or simple construction delays or both?
Both Both. The intention is specifically if there are weather delays, and Sunday is needed as makeup day.
Your amended site assessment report filed in February indicates that all the residences involved are outside of the 45 decibel sound contour. Is that at all times including pile driving?
The noise assessment regarding the 45 decibel limit, that is regarding operational noise. Based on preliminary design, all of the homes are outside of the 45 decibel limit. That is not the case during construction.
In your response to the Harvey recommendations, there has been an objection to using additional sound blanketing measures during the pile driving or heavy construction, and you've indicated some reasons, chiefly with regard to it's not the industry standard or perhaps would be too expensive. Can you expound on the reasons why that would be so difficult?
Yes, Caldwell Solar is not aware that the recommended noise suppression for pile driving methods are proven or practical. The adding of, for example, sound blankets on fencing can be a very expensive and timely effort to add the coverage around the fence. It can also be difficult to actually attach those to the type of fencing we're using. And then we're also not sure of the practicality of other suppression methods that have been suggested, such as moving a covered trailer around. And we do have our noise expert, David Hessler, on, who can speak more to that issue if you have further questions.
In your amended SAR, you indicated you all would need to obtain a floodplain permit, and I suppose later a stormwater pollution prevention plan. Are those completed yet?
No, we have not obtained or applied for any floodplain water or stormwater permits at this time. We will do those prior to construction.
You've stated that there are no schools, hospitals, or nursing homes within 2,000 feet, and churches were not mentioned, other than we had questions concerning the White Sulphur Church, which is 3,300 feet away. Have you all reviewed any possible impact from traffic holdups or traffic patterns in construction to that church?
In our road analysis and our site assessment report, I don't recall that we specifically spoke to traffic relating to the church. As you mentioned, the church is several thousand feet away, and it's not straight off the main road from my recollection, so we don't anticipate major impacts to transportation to that church. In addition, Sundays, which is a common church time, we are not proposing having construction every day, just in makeup days.
Are there any other churches that you're aware of? I did not see any listed, but perhaps I missed them within that.
I am not aware of other churches in the near the project.
You've indicated the substation will be 1,000 feet away from residences, and that panels and string inverters will be, I believe you said 200 feet away, although you then indicated 300 feet from residences in certain residential groups. Can you explain the request to make sure that that is the accurate statement of what you're proposing?
Sorry, could you repeat the question?
Yes, let me try to rephrase it. It was pretty awkward. As far as the substation, you said 1,000 feet away from residences, although it's not located yet, correct? And then you've said several times the inverters and panels would be 300 feet from any residence. However, then you indicated 200 feet in a different motion for setbacks for panels and inverters from residences. And I believe you may have been referring specifically to some residential groupings. So I'm just trying to have you explain specifically what the setback request is in your motion.
Sure. In the setback deviation, we are requesting a setback of 300 feet from residential neighborhoods. Outside residential neighborhoods, a 300-foot setback is for panels and inverters. Outside of residential neighborhoods, we are proposing a minimum 200-foot setback from residential homes or occupied structures. And that's again for panels and inverters. For the substation, we are proposing a minimum 1,000-foot setback from for the substation from nearby homes or occupied structures. In our design, we are well beyond the 1,000 feet, the preliminary design, but we're asking for a minimum of 1,000-foot setback for the substation.
Ms. Pelicero, can I ask a clarifying question? When you say inverters, are you referring to both string inverters and central inverters, or are you referring to one or the other?
Our preliminary design uses central inverters.
Okay, so the minimum setback that you're proposing is 200 feet from a residence, the distance from a residence to a panel and a residence to a central inverter?
Yes,
Okay, and the project is not proposing any batteries, is that correct?
that is correct.
Okay, thanks.
Have you all discussed or planned anything with regard to fire safety, either in or around the locked premises once the project is complete and locked?
Yes, National Grid Renewables and Caldwell Solar take safety very seriously. We will be meeting all National Electric Code safety measures. Prior to construction and operation, we will have a meeting with emergency aid authorities to make sure that in case of an emergency, that all of the necessary procedures and contacts are available. There will be contact information on the locked gates as well.
In your decommissioning discussion, you chiefly disagree with the recommendation from Harvey that all parts below ground be removed. And you've indicated that you wish to leave some electrical collection lines that may be below 3 feet and any pieces, I guess, of the piles that are below 3 feet. Is that a correct statement of what you're proposing?
Yes, that is correct.
Could you explain why you would not be in a position to remove everything below ground?
Yes, the removal of underground equipment more than a depth of 3 feet can result in more ground disturbance than is necessary. It's common in jurisdictions nearby to the site, as well local jurisdictions, state jurisdictions, to limit decommissioning to a depth of 3 feet. It is our intent that if we can easily remove equipment below a depth of 3 feet, that we will, but in the case that it would result in more disturbance or after than is needed, then we would leave the materials below a depth of 3 feet. And the depth of 3 feet is below the plow line or typical activities that would result in any of these materials being impacted or being in the way.
There was a discussion that in your restoration of the property, you may leave the substation if a subsequent agreement necessitates it. Since that response was made, has there been such an agreement made?
No, not that I'm aware of.
I believe the other witness is supposed to be the one who answers transmission system questions. Is that right? Okay.
Yes, that's correct.
On the issue of property valuation and the effect on surrounding properties, there's quite a discussion concerning the 10 examples that the Cohn-Resnick report relied upon, and each of them are substantially less than the acreage and the number of panels in this particular project. for example, 8 of them are 500 or less acres and 2 are 1,000 acres, whereas we've got 3,000 acres here with 1,449 acres behind fences. So there has been some discussion of this as to whether those smaller projects are relevant. Can you explain further how the assumptions related to those 10 examples are transferable to this larger project?
I would defer to Andrew Lyons, the subject matter expert, on the methodology and applicability of the study.
As to your maps and site plans, we had a bit of a discussion yesterday with council on this issue. There are several different site plans, of course, filed throughout. The most recent were filed in January 12, 2022. Is that the most recent site plans that are available?
I will defer to council if that is the latest date we filed the amended Exhibit J.
Yes, that's correct.
All right, there is a slight difference on that one, so it is a little bit different, particularly with regard to residence number 74. So that is the most recent. In that same document, however, it refers to, I believe, a figure 3, and I believe we determined yesterday that figure 3 was not amended from the earlier submission. Is that your understanding as well?
Yes, that's my understanding.
That's correct.
You submitted a Caldwell public information meeting preliminary layout map. I believe it may be in the confidential files, but I'm not going to ask questions about that. What I can ask about, however, I think without getting into that, is what public meeting was that map presented? At what public meeting was that presented?
That map was presented at the 2021 public information meeting.
As part of your PowerPoint type presentation?
It was standalone from the PowerPoint presentation. The PowerPoint slides were printed out at different stations. And at one of the stations, we had a large map that showed the site and what it may look like if panels were on the site, preliminary layout.
And in that particular map from the 2021 meeting, there are a couple of areas that are what I would call an expanded boundary that are not evident in subsequent submissions. Are there plans to move into those expanded boundary areas?
The boundary in the most recent filed materials, the boundary shown in the application, that is the plan. There's no plans to expand beyond what was submitted in the application materials.
Okay. I believe that's all. Thank you.
Thank you.
All right, Vice Chair, any questions? Or I guess, sorry, Deputy Secretary Lyons, any questions?
Yes, Mr. Chairman, thank you. Good morning, Mrs. Pelicero. Actually, I do want to just follow up on what Ms. Gosnell asked regarding boundaries. Oftentimes, the acreage and the footprint of these projects is always rather confusing about what's the acreage of the footprint versus the project boundary itself. And I've seen several different figures. I think in your application and description, it says 3,000 acres. But then I read in the Karst report that there was plans on expansion from the original 2,000 by another 1,700 acres. Can you clarify what the total acreage here is, what the footprint of the arrays are versus the acreage of the project itself?
Yes, the total acreage of the project site is around 3,000 acres. If you look at Exhibit J, the plan set, in the upper right corner, it will have the breakdown of how many acres are within the fenced area, which is where the array is located, which is a smaller acreage. I don't recall the exact acreage, but I do know it is presented in as a picture.
So does that mean that 3,000 acres will be leased?
It is possible that the full 3 acres would be leased. It is also possible that a reduced lease area will be created once we finalize design.
Okay, thank you. Moving into a little bit more questions in my area of expertise, I noticed in the SAR site assessment report that a 401, 404 stream and wetland delineation or jurisdictional determination would be made. Has that been done yet?
We have completed a wetland delineation. We have not yet submitted our request for a permit application for a jurisdictional determination. We plan to do so soon.
Okay, yeah, we would like to see that. I don't know if that needs to be a post-hearing data request or not, Mr. Chairman. With such large acreage here, what is the general, since you've done that, what is the general plan for dealing with jurisdictional streams and wetlands? Is it avoidance or nationwide permits for stream crossings? What's the general idea there?
Yes, based on our preliminary design, we're able to avoid most wetland impacts. The solar array area in the preliminary design is avoiding wetlands or streams. It's possible that we may have a few roads or crossings over jurisdictional wetlands. In that case, if a nationwide permit was needed, then we would apply for one.
I think also I saw where you plan to use on-site water. Are there any water wells? There really wasn't. I don't guess there was a phase 1 environmental assessment done of this property that I saw. Is that correct?
We have completed a phase 1 ESA. We did not file it as part of the application.
We would also like to see that as well.
Yes, we can provide that.
Thank you. What about certain endangered species? Have you done an IPAC or have you used the Kentucky Biological Assessment Tool to do that?
Yes, we've completed both. The protected species in this area are 3 protected bat species that were identified. Impacts to the species are only anticipated in the case of clearing large intact forested areas. We have cited the project to minimize impacts and minimize the need to clear large forested areas. We have initiated consultation with U.S. Fish and Wildlife. If the design changes and impacts to large intact forested areas are necessary, we'll continue that consultation with U.S. Fish and Wildlife and follow any recommendations for mitigation.
Were there any karst features that could be hibernation areas for those bats?
I'm not familiar if the karst features could be habitat for bats.
Well, that should certainly be covered in the assessment, if so, because there are karst features that could serve as that, from what I can tell from the karst report. That was a quick overview on my part. But moving into the karst report, just a couple of questions I have there. I noticed in your application that.
Mr. Lyons, if I could,
Sure.
I think we filed that under seal, did we not, the karst report? Could we perhaps go off the record and have that discussion?
I'll defer to the chairman on that.
Yeah,
Mr. Chairman.
So I guess the first question is, you filed a karst report under seal of confidential, under a request for confidentiality?
That's correct.
Okay, I haven't seen that one yet. So, given that's the case, if Deputy Secretary Lyons, well, let me first ask, council, Is this the witness to answer questions about that report, at least initially?
Initially, yes, Mr. Chairman, but if we want to get into more detail, we probably want to speak to Mr. Ben Taylor with Terracon who performed that study.
Mr. Chairman, maybe this might help. My question is about the setbacks that I saw in the application, not in the karst report.
Yeah, I think we can speak to that, Mr. Lyons.
Okay,
The various setbacks for sensitive areas.
yeah, I just had a question. There were two mentioned. One was a 50-foot setback from a sinkhole, and the other was a 15-foot setback for a karst feature. Obviously, a sinkhole is a karst feature, so I'm really not sure of the difference there and why one is so much shorter in distance than the other. That's primarily my question.
Yes, I can answer that question, high level. In the division between 15-foot setbacks or 50-foot setbacks comes from the risk level of the karst feature. In the karst report, you'll see a description from low to high risk.
Right.
So it's been recommended from our consultant that in the higher risk areas, which in that response were referred to as sinkholes, I think it'd be a more appropriate description in this case to say the higher risk areas shown in the report, that a 25 to 50-foot setback be followed. In areas that are lower risk, maybe more closed features, 15-foot setback would be adequate.
Okay. That's all the questions I have, Mr. Chairman. Thank you.
Mr. Montgomery?
No questions for me, Mr. Chairman.
All right. Is Miss Cherry with us? I don't see her name up here. I want to make sure she hadn't called in. Gail Cherry?
I believe she's with Judge Curling, Mr. Chairman. It looked like they were together.
All right. Judge, are you there?
Yes, we are both here.
All right. I guess I'll ask Miss Cherry first. Do you have any questions for Miss Pelicero?
No, I don't think so. Thank you.
Okay. And Judge Curling, do you have any questions for Miss Pelicero?
There was another church that was not addressed. It's at the beginning of Crider Road, and I don't know if y'all was aware of that or not.
We stood in the parking lot when the research team, lack of better understanding, or lack of a better term, was here and discussed the hours of operation.
Hey,
And
Judge,
not parking lot of the church.
Judge, are you speaking?
So this is Jeff Boone.
So Judge,
On fiscal court too.
yeah. So Judge, only you and Miss Cherry are on the sighting board. So you're going to have to limit your questions to either you or her of any of the witnesses that are present. So if you have specific questions you'd like to ask, you can do so with Miss Pelicero. But we don't have an opportunity for anybody else to participate. And anything that you all want to do has to be done in the form of a question rather than a statement.
It's just that church. They were pretty much all around that one church on Crider Road, and it was not addressed.
Okay. Hey, can you just for a second, Judge, tell me how to spell Crider Road?
Crider.
All right.
The Watson property is around that church, and that's where a lot of the solar panels are going to go.
Okay. All right.
The
So-
Meyer D.
So I think what may be best on this, Judge, if it's okay with you, we'll ask the company in a written post-hearing request to provide information on how close any of the proposed facilities are to that church, and if there are some that are close, how they propose to mitigate the noise and view shed issues related to that church.
Thank you.
Judge? Judge, do you have any additional questions?
No, I do not.
Okay, thank you. Vice Chair Covich?
Yes, I have a few. Good morning, Ms. Pelicero. Thank you for being here today. My first question is, does NGR expect to operate this after construction, or do you expect to market this for another operator?
Yes, it is our intent to own and operate after the Caldwell Solar project after operation,
Okay.
or after construction.
And this, I don't think will be something that we'll have to worry about the confidentiality petition on the car study, because this is more about NGR's experience. But what kind of experience does NGR have in dealing with heavily karst sites in constructing a solar facility?
Yeah, to my understanding, Caldwell Solar has not constructed a renewable energy project with this level of karst, but we have worked in several different areas with unique site geological constraints, and we, our EPC partners who will construct the solar facility are, tier 1 EPCs that have experience working in a multitude of different geological conditions, and when evaluating our EPC choice, we will take consideration into experience in karst areas.
Okay. The 3 abandoned cemeteries that I believe were delineated in response to a data request. It was represented that they are fully abandoned, that no one appears to visit them, but there would be coordination with the Heritage Council about that. Has anyone reached out to the Heritage Council yet to do that?
Yes, we have submitted a letter to the Kentucky Heritage Council describing the 3 cemeteries and our plans for mitigation. That letter was sent, forgive me, I forget the date, but it was in the past couple of weeks. This month, I would say.
Okay. I mean, one thing I would say is I don't doubt that they're probably truly abandoned cemeteries, but with the interest in genealogy and people looking for ancestors, I would be prepared for requests and how you might deal with those people who do want to try to find those cemeteries on a one-off kind of basis. Other than that, I am going to have questions about the karst study, but I will save those for the consultant, and we can do those in closed session. Thank you.
Thank you.
Commissioner Butler, any questions?
Just a couple. Good morning, thanks for being with us. I was looking at Exhibit H, and it looks like there are 2 residents within the boundary of the fence. Is this just an old map? Or are there gonna be people living in the middle?
If there are homes that are identified in the area of the site, they wouldn't be fenced in. They would be outside of the fenced area. So we're not doing the project.
It shows them fenced, but I can't tell if there's a access road for them to get to their home.
Yes. Any landowner will have access to their road, to their home, to their buildings, will have access.
And there is a railroad that follows, I guess, the east side of your property or the proposed property. You're not gonna have any railroad crossings? You don't need any permission from the railroad to do anything?
Yeah, our project does not plan to cross the road with any permanent infrastructure, with electrical crossings or facility or roads. We will have, during construction, have to cross over the railroad. Any special coordination with the railroads is needed. We'll complete that with the railroad.
Now, sometimes they can take their time.
Yes.
And I just had another one, when I was looking at stuff, it said that you were gonna set up a charitable fund. I'm not sure if you're the person that can talk to that, or if there's someone else.
Ellie DeBleek would be the witness to speak to that.
Okay, I'll save that question. Thank you.
Thank you.
So I have a few questions, but I guess I'll start with this. Just, I guess 3 weeks ago, maybe 4 now, National Grid also filed a renewed notice of intent for the Golden Solar project that had, I guess, laid dormant since its initial notice of intent. Given that it was not an active case, and I guess technically is just now an active case again in January, it's my understanding that there's not been any discovery or any significant discovery in this case about the interaction of the two projects. And I didn't see anything in the consultant's report about the two projects. So is it your understanding that those two projects are proposed to almost abut each other?
Yes, the Golden Solar project and Caldwell Solar project are adjacent to each other. Golden is north of Caldwell Solar. There's a road and or railroad in between the two projects.
Okay. And so I guess would you agree that none of the proposed mitigation, either initially by the applicant or in response to the issues identified in the consultant's report or throughout discovery, take into account the fact that these are going to be proposed to be co-located?
The mitigation measures don't specifically speak to the fact that these projects are relocated near each other. It's possible that they are constructed around the same time and operational at the same time. It's also possible that they aren't constructed at the same time. The mitigation measures proposed by Caldwell Solar to specifically address the construction and operation of Caldwell Solar. But the mitigation measures, I would say, would, by limiting construction hours and coordinating with local communities, road authorities, all of those would apply to a similar project and are put in place to mitigate impacts to the neighbors, even in the case if there was a nearby project being constructed or operational around the same time.
Right, but effectively, if we're going to put mitigation requirements, out of consideration that they're going to either be proposed at the same time or operated right beside each other, that our only real opportunity to do so will be in the Golden case, right?
I would say that National Grid Renewables sees Caldwell Solar and Golden Solar as two separate projects. And when we're applying for mitigation measures, we're anticipating them to be project specific to this project. And then in the case of Golden Solar, yes, Golden Solar would have its own mitigation measures.
So was Golden Solar initially anticipated to be built before this project? Do you remember?
I don't recall the exact schedule of these two projects and which one was proposed before the other. It's a big moving target.
Okay. So both of the projects, we'll focus on this one for a minute. Border the, I don't know who owns it these days, but the quarry there in I guess just outside of Fredonia, right?
Yes, that's correct.
So what sort of interaction is expected in terms of traffic, noise, air or noise pollution? What sort of interaction is expected, and what sort of measures are you all taking to account for that quarry, especially since it, as I understand it, is still operating?
Yes, the quarry, speaking to Caldwell Solar, is on the adjacent to the northwestern portion of the project. There will be some co-use of roads. off of Kentucky 91, which is one of the main roads we will use to access the Caldwell Solar project site. It's also a main road for the quarry. The quarry does have a direct access off of US 91. There's also another access to the quarry around the southern part of the project that may involve co-use with Caldwell Solar project. So there'll be some shared roads, but the quarry does have multiple access points that are not going to be directly used by Caldwell Solar. We plan to contact the quarry, work with them, and make sure that we stay in touch and can plan together the use of roads and traffic.
So how about, I mean, they're going to continue to extract there at the quarry. Do you all have concern with the life or condition of assets placed in the general area?
No, not that I'm familiar with.
Okay. Are you aware of the maps generally? I mean, the maps that have been filed in this case?
Yes, I am.
Okay, and you've seen the 811 logo that's on a significant number of the maps?
I don't recall.
Are you aware of 811 generally?
Yes.
Okay, and do you understand it to be a sort of a nationwide program for call before you dig in anticipation of digging and concern for underground facilities?
Yes, I'm generally familiar.
Okay, and are you aware of whether any of the states that you've worked on these projects or in Kentucky that there are exceptions to where for certain processes or for certain people or for certain fact patterns that a person doesn't have to actually call before they dig?
I'm not familiar with different cases of where you do or don't need to call before you dig.
So related to the proposal for the company's insistence on leaving underground facilities that are in excess of 3 feet, when will that 3 feet be measured? At the time of putting those facilities in, or at the time it's to determine whether or not they should be removed?
I would assume that the measurement would be done based on final design. So final design, I would anticipate we would have diagrams and site plans, which would show the level of where the underground facilities are. At the time of decommissioning, more measurements may be done to confirm the depth of the underground equipment.
Would you agree that for a project that could be operating in excess of 30 years, that it's possible or likely that there will be any amount of erosion over this 3,000 acre property?
I would say that yes, there is a possibility of erosion over 30 years with any type of development.
Right. And going back to what I was asking about 811, would it surprise you to find out that there's an explicit exception in the 811 law that provides that farmers tilling on their own farm do not need to call 811 ahead of farming or ahead of that tilling? Would that surprise you?
No, that does not surprise me.
Okay. And so I guess what I'm asking here is if we're putting cables under the ground and leaving them there for decades, and they were, let's say 3.5 feet in the ground at the time, I just want to make sure I understand your all's proposal is to then leave it there at decommissioning, regardless of whatever the land use is after the fact, that it will be left up to the landowner to take care of those facilities or to extract them underground?
Yeah, so decommissioning, after the site is decommissioned, the leases will expire and the land will be up to the landowner for care and land use as they see fit.
Okay. The last question I have is there's one specific residence that is the closest to an inverter. And over the past, let's say 15, maybe a dozen cases that the siting board has had, we've required that facilities not be located closer than 150 feet to a non-participating home for string inverters and panels, and 450 feet for central inverters and we'll just call them battery energy storage systems. And there's at least one under the current, or I don't know if I guess assume it's the preliminary report. There is one home that is located 391 feet to an inverter and only 94 feet to the project boundary. Other than non-participating 74, this non-participating residence 59 seems to be the closest facility or the closest home to the facilities. And I'm just curious, given the proximity to the inverters, which, as I understand it, other than the substation, are anticipated to emit the most significant amount of noise during operation, has the company had explicit, or the applicant had explicit conversations with that homeowner?
I don't recall that we've had explicit conversations with the landowner. I can say that we have completed our noise assessment report, which included that home. And since that's, the nearest home, the report showed that even during daytime, that the operational noise from inverters is under 45 dBA. The EPA standard for daytime is 55 dBA and nighttime 45 dBA. So even during daytime, at that nearest facility, nearest home, nearest receptor, the noise level is anticipated to be under 45 decibels based on preliminary design.
Well, I'm well aware of 45 versus 55, and I'm also aware of what the EPA actually describes 55 as being. I don't know that that's, quote, a standard. That is a description, I believe, and the EPA standard will speak for itself, but I think that's a description before something is, quote, annoying, is at least my memory. And so I'm not specifically asking about whether the anticipated decibel level is or isn't a certain amount. What I'm asking is, I just want clarification, that you're unaware of whether whether you all have spoken to that homeowner about the anticipated either noise or visual impact.
Yes, I am unaware if we've specifically spoken to that landowner, but that is something that we are happy to do as a follow-up.
Okay. Mr. Bentley, do you have any redirect?
No, Mr. Chairman, we don't.
Okay. And Ms. Pelicero, given your sort of nature as being one of the two primary witnesses, I'll ask you to step down from I know you're not technically on the stand, but step down from the stand and just wait for us to finish this hearing before we're allowed to excuse you.
Okay, will do. Thank you.
Thank you. Mr. Bentley, would you like to call your next witness?
Thank you, Mr. Chairman. At this point, we would like to call Ms. Ellie DeBleek from National Grid Renewables. Ellie, can you hear us?
Yes, I can. Can you hear me?
Yes.
Great.
So, Ms. DeBleek, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Mr. Bentley, you may ask.
Mr. Bleak, would you state your name and title and responsibilities for this project?
Yes, my name is Ellie DeBleek. I am a developer at National Grid Renewables and was the primary developer on the Caldwell Solar project.
And did you assist with preparation of this application?
Yes, I did.
And are you familiar with its contents and your role in providing certain responses?
Yes, I am.
Yes. With that, that, Mr. Chairman, we would tender the witness for cross-examination.
Ms. Gosnell?
I just have one question. The application and the various information provided indicates that you did apply with the Mid-Continent Independent System Operator to get your evaluation, and it indicated you expected a report first in July, and then again in December. Have you actually received anything recently from them concerning their studies?
We have not. They have posted delayed study timelines. We now anticipate, based on their current schedule, to receive the first study in March of this year, and subsequently receive the second study in June of this year.
That's the only question I had for this witness.
Deputy Secretary Lyons?
No questions, Mr. Chairman.
Mr. Montgomery?
Good morning. I think some of my questions are going to be more tailored towards the expert witness, but I'm going to go on ahead and try to ask them, and of course, feel free to defer. When it comes to the operational phase of the, I guess I need to back up. I'm looking at Exhibit F, the Economic Impact Report in the application. And in terms of the operational phase, it shows that there are 5 full-time jobs. Would those be from folks locally, or is this something that requires outside employment?
For the full-time equivalent operational positions, we try to hire as local as possible. It's just dependent on availability of candidates within the local area with the necessary skill sets for those jobs.
Now, is there a specific SOC code used to identify the operators? If so, do you know which one it is?
I am not aware of that.
Okay. That's all the questions I had, Mr. Chair.
Ms. Cherry, do you have any questions?
Did you mean Mr. Judge Curlin?
Well, I think Ms. Cherry is with Judge Curling.
Oh, okay.
Yes, can you hear us?
We can.
Okay, I have no questions.
All right, thank you, Ms. Cherry. Judge Curling, any questions?
Just not, he stepped out just for a second.
All right, thank you. Vice Chair?
No questions.
Okay. Commissioner Butler?
Yes, I just have a couple, thank you. I noticed that you said, or the company said they would set up a charitable fund with $40,000. Is this something you do at all of your sites, and how did you arrive at 40,000?
Yes, so we set up a charitable fund for our large-scale utility wind and solar projects. So it is typical for us to do this across all of our larger scale projects. The $40,000 is based on the assumption that we donate up to $200 per megawatt per year. So $200 based on the 200 megawatt size project.
And how would people, is this money that is spent within the community or the county in which the project is located? And do people, I'm assuming, well, I'll let you answer how you distribute it.
Sure, so we typically will gift this donation to one entity, and we customize how these payments are made based on the community's needs. In Caldwell County specifically, we haven't determined yet where the funds are gonna go, and that will be based on conversations that we have with Judge Curling and other community members. Sometimes our charitable funds have taken the form of an education fund where the money is donated directly each year to the local school district. and then that school district can spend the funds however they see fit. Subsequently, if we were to set up the fund to donate directly to the county, we would gift the money, and the county, it would be up to their discretion of how they choose to spend it. And this money is on top of any tax revenue that's
Thank you very much. That's all.
So, Mr. Bleak, do you know if Caldwell Solar anticipates attempting to enter into an industrial revenue bond with the county to finance the construction of the facilities? We've lost our feed.
It looks like it.
So we'll just have to wait.
Did you lose your audio?
Can you all hear us now?
Or did we lose our audio?
And each other. Just periodically, I think they're trying.
Madam Vice Chair.
You're welcome.
Can you hear us now?
I'm having some internet connectivity problems even here on, plugged directly in. I don't know if it's storm related, but it could be a problem.
Okay.
Can you all hear us? We're still on for you? Still going? Okay.
It doesn't look like the lawyers for McBrayer can hear us, or surely they would have spoken.
So Anthony, will you unmute, see if that worked? All right, can anybody hear us? Can you hear us now?
The,
Can you hear us now? How about now?
Yes, it's the goal of Caldwell Solar to do so. We've only had preliminary conversations, however, with the county thus far.
Mr. Bleak, can you hear me?
Yes.
Yes, Mr. Chairman, we can hear you now.
All right, sorry about that. I think we'll blame it on something with state government. It's just the easiest thing. Nobody ever defends it. So
now we can't hear you if you're talking.
okay, so can you hear us now?
Yes.
All right, so we need to restart our computer. I think that is running our.
You're going in and out.
Yeah. Yes, Mr. Chairman, we can hear you.
A little staticky, Mr. Chair.
So I'm gonna say 7, the letter 7. Can you all repeat 7
No.
to me?
We lost. It's very garbled. Yeah. Mr. Chairman, we're not able to follow you. It's cutting in and out.
Yeah, I think we're gonna take a break and come back at 10:20.
That sounds like a good
correct,
plan.
Chairman?
Will you
We'll
turn
be
off
recess until 10:20.
and stop?
All right, thank you.
Great. Vice Chair, can you hear me?
We can hear you.
Great. We're back on the record in case number 2020-0022244, excuse me. Mr. Bleak, can you hear me okay?
Yes, I can.
Okay. So you're still under oath. There was a significant delay, 2 or 3 minutes between the time I asked that last question and the time you got to actually answer it. So I'll just ask it again for clarity of the record. Is the anticipation or I guess plan for the applicant or for National Grid to enter into an industrial revenue bond agreement with the county in order to finance the construction of this facility?
Yes, it's the goal of Caldwell Solar to enter into an IRB with Caldwell County. However, we've only had preliminary discussions with the county thus far.
And I understand that the applicant here is Caldwell Solar, but has National Grid or its predecessor companies entered into an industrial revenue bonds for any other projects in the state?
We have not.
Do you plan or have had discussions to enter into industrial revenue bonds with other projects?
Yes, we plan to. I believe it's the goal with all of our projects in Kentucky to do that, but again, we're just in preliminary discussions.
Okay. And with that, is it your all's expectation that in addition to payments to the county, those payments in lieu of taxes, that you all would also expect to consider making payments to the school district?
Yes.
Okay. And are those taken into account, is your understanding in the economic, the economic impact, I guess, study that was done in this case, either those pilot payments to the county or pilot payments to the school board?
I do not believe that the pilot payments specifically were accounted for in the economic report.
Okay. And so whatever benefit, for instance, well, I'll just ask, so there's a presentation that was provided as part of the application, and I think it's your presentation that maybe you've given in the past to the June 17th, 2021 Caldwell Solar Public Information Meeting. It's Exhibit C to the application Exhibit, I think A. No, it's Exhibit C to the application, excuse me. It's a page 24 of 83 of Exhibit C. Do you know which presentation I'm discussing?
Yes.
So there's a portion of it that discusses the project economic benefits, where it discusses the estimated tax revenue, capital investment, goes on and on and on. And then it talks about the education fund. And what I want to make clear is that after your discussion with Commissioner Butler, that education fund of $40,000 a year is unrelated to the possible pilot payments to the school board, correct?
Correct. The charitable fund or education fund, whichever form it takes, is completely separate from the pilot payments.
Okay. And then there's, as page 62 of that Exhibit C, there's another, I'll call it a one-sheeter, one-pager, excuse me, that talks about the project. And as part of it, it talks about a $6.6 million impact over 25 years, and it has a pie chart where it breaks down the tax revenue distribution projections. Is it your understanding, again, that it says that there's $4.8 million for school districts over 25 years? Is that take into account what the anticipated pilot payment to the school district would be, or is that over and above? Is that separate from what those possible pilot payments to the school district would be?
Those numbers are assuming that the pilot payments are included there.
Okay, so this that was, I guess, going to be my other question, where such a small amount of the taxes there are going to the state. That assumes an IRB is entered into that provides for pilot I know that the word payment is redundant when I say this, but pilot payments to the county in lieu of tax payments to the state, correct?
Yes, that's correct.
Okay, so we have a little bit of a delay again, so I'll try to rush through this before we need to take another break. I don't know what's going on. If I have additional questions as to how those numbers were calculated and what the difference would be between having a pilot and not having a pilot, or I guess effectively having an IRB, entering into the IRB and not entering into the IRB, would those questions be best for Mr. Zoller? Mr. Zeller?
Yeah, I can speak generally to that, but anything that's more detailed, I would like to defer to Mr. Zeller on those.
Okay. And I guess my last question is, to the line of questioning I had from Ms. Pelicero, it's my understanding that National Grid has been having these discussions at the county level, not necessarily hiding the fact that they are planning a 200 and a 150 megawatt project. I mean, I've seen news reports, even back in 2021, I think, where you were giving presentations to the fiscal court talking about, the two different projects and providing maps as to their location. But I guess that leads me to my question of, has anyone, have you received any significant feedback from either officials or citizens, residents of the county about having both projects in such close proximity or constructed near to each other, either in time or location, as opposed to their individual perspective on just having one or the other project?
We really haven't received comments, particularly negative comments, related to the fact that there are possibly going to be two projects adjacent to each other. When we have presented to the county, we typically have been presenting Caldwell Solar and Golden Solar as two separate projects, but we do typically, or in the communications that we have had or presentations that we have made, we have presented materials on both projects. So we've tried to be pretty open with what the proposals are, but we haven't really received any negative comments. Going back to your question, specific to the fact that the projects would be adjacent to each other.
Okay. And finally, have you received any concern or negative feedback from the quarry being in such close location or sharing so many roads, or the time of, especially over that however 9 to 18 month construction period would be?
We have not received communication back from the quarry, but that is a relationship that we anticipate to continue. But no, at this time, we have not received any negative type of feedback from them.
Okay. All right, thank you, Mr. Bleak. Mr. Bentley, any redirect of the witness?
No, Mr. Chairman.
Okay. This may be a good time to take, well, let me ask this. Let's see if, well, we don't have the judge back yet. It doesn't look like. Here we go. Judge Curling is back. I'll wait just a minute. Judge or Miss Cherry, do either of you all have particular questions for any of the remaining witnesses? Anything that you would like to know, get information from any of the folks from the company on the record?
No, we do not. Sorry I was late, but we had a fiscal court meeting.
That's perfectly fine. We've all had things come up today, so that's fine. I'll just ask real quickly, Deputy Secretary Lyons, do you have any additional questions specifically, or specific to any of the other witnesses that you would like to ask, maybe on the karst issues?
I do not, Mr. Chairman. Thank you.
Okay. Vice Chair Cubbage, any questions?
I will have a few questions on the karst issues.
Okay. And as I understand it, that's Benjamin Taylor, correct? Mr. Bentley?
Yes, that's correct, Chairman.
Okay. Commissioner Butler, any other witnesses that you would like to keep around?
Yes, sir.
Okay. Mr. Montgomery?
Yes, I'd like to hear from Mr. Zoller.
Okay. So it's 2 from Mr. Zoller. Anyone else? Mr. Montgomery? You can shake your head if you want. So what we'll do at this time, we'll take a quick, let's say, 10-minute break again. Well, let's just give us 12 minutes. We're going to reset again our computer. It's going to kick everybody out, but it does seem like there's a glitch, a small delay in when I'm speaking and when you all can hear us and vice versa. So let's take a short break until 10:45, and we will take Mr. Taylor and Mr. Zoller. Given that's the case, I think that we can excuse witnesses Morris, unless anybody has an objection. Or, I'm sorry, all of that being said, do you have any additional questions for any of the witnesses?
I think the one witness deferred to the let me see what his name is. Cone Resnick representative, Mr. Lyons, she deferred on his discussion of how the smaller projects were relevant to the property valuation issues. That was the only thing that was on my list that she deferred on, or that these two
That's
witnesses deferred
Mr.
on.
Lyons. Would you like to bring Mr. Lyons?
That was Mr. Lyons,
Do you have questions for Mr. Lyons?
just that one.
I'm sorry, do you have any other questions for any of the other
No.
witnesses? Okay, so after we come back from the break at 10:45, we will be asking Mr. Bentley or Ms. Eckert for the applicant to call Mr. Lyons, Mr. Zoller, Mr. Taylor. But it would seem that the remaining witnesses, with the exception of Mr. Bleak and Ms. Pelicero, can be excused from the hearing.
Thank you, Mr. Chairman, that works for us.
All right, great. Unless you would like to call them, but I think you had indicated at the outset of the hearing that you were just having them here for our benefit. But don't get me wrong, you're welcome to call any witness you would like in support of your application.
We appreciate that.
Okay. All right, we'll take a short recess until 10:45. Can you hear us, Deputy Secretary? Great. We're back on the record in, we're missing Commissioner Butler. We'll go ahead and get started. We're back on the record in case number 2020-00244. Mr. Bentley, Ms. Eckert, would you like to call your next witness? Oh, you're on mute, Ms. Eckert. One minute. We don't have it in the room. Now we do.
Okay, can you hear us, Mr. Chairman?
We can. Hold on 1 second. Now try.
Mr. Chairman, we'd like to call Benjamin Taylor as our next witness.
Okay. What? I got you. So, 1 second. We're having audio issues now, but we could hear you call the person. So let's. Could you repeat what you said?
Yes, Mr. Chairman, we would like to call Benjamin Taylor as our next witness.
So we're gonna have to we're gonna stay on the record. We're not going off, but we're gonna need to fix our audio. For some reason, we can barely hear you. So, Vice Chair, will you try to speak to see if, make sure that it's not just their microphone, but I think it is our audio.
Testing.
Yeah, we just can't hear you. We can't hear you near as well as we used to.
We've got our volume all the way up on our end, Mr. Chairman.
Yeah, it's with us. Will you try it again, Mr. Bentley?
Yes, Mr. Chairman. Can you hear us better?
Not necessarily.
We've got Ms. Eckert has the speaker pulled
There
up
we go.
close to her.
We fixed it. We were using the wrong input. We were using the wrong input for speakers. So,
Okay.
All right. So, Ms. Eckert, was it Benjamin Taylor that you had called?
Yes, Mr. Chairman.
Okay. Mr. Taylor, please turn on your microphone, your video, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Ms. Eckert? Oh, I'm sorry. Mr. Taylor, please state your name and address for the record.
So Benjamin Taylor, and you said my name and address?
Yes.
Okay.
Professional address.
What was that? Sorry.
Your professional address, please.
Okay. I'm a professional engineer and professional geologist.
What's your address, your work address?
Mr. Taylor, can you give him your work address?
Okay. I'm sorry. My speaker mic went out. Can y'all hear me now?
We can. Can you provide your work address, please?
Yes. It's 13050 Eastgate Parkway, Louisville, Kentucky 40223.
All right. And Mr. Taylor, we've lost your video for a minute, but we had it at the outset, so we know who you are. As long as we have good audio, we're going to keep pushing forward. Ms. Eckert, you may ask.
Mr. Taylor, which company are you employed by?
I'm employed by Caldwell Solar.
Well, I mean, are you with Terracon?
I'm with Terracon Consultants, yes.
And are you here today to testify about the Terracon report for the karst survey.
Yes, ma'am.
Mr. Chairman, we tender the witness.
Ms. Gosnell, do you have any questions for this witness?
No.
Deputy Secretary Lyons?
No questions, Mr. Chairman.
Okay. Mr. Montgomery?
No questions, Mr. Chairman.
All right. Judge and Ms. Cherry have already indicated they don't have questions for any of the remaining witnesses. So, Vice Chair Cubbage?
Yeah, I have a few, but I guess before I launch in, do we need to do this in closed session off, not broadcast?
Yeah. Are you asking questions about the karst study that was filed under petition for confidentiality?
I'm not asking very detailed questions about it. I'm asking more generally about the site and the conditions on it. I'm not asking about any particular spots or distances, but that may still, Mr. Bentley and Ms. Eckert may still have wish to keep that confidential for now.
Vice Chair, I believe that we, discussing those will go into the portions of the karst survey that were provided under seal. So I believe it would be best to do this in confidential session.
Okay. So that's what we'll do. And if the citing board ultimately, denies the petition for confidentiality, we'll certainly make this portion of the hearing public. So we'll take a short break here. I just want to make sure before we go, Ms. Eckert, that with the exception of Mr. Curling, obviously a member of the citing board, Ms. Cherry there with him, that everyone else on the video is either a citing board member or with the applicant.
Caller 01. Do we know who caller 01 is?
Judge Curling.
Yeah, I believe that's Judge Curling's audio for caller number 1.
Then, yes, to the best of our knowledge, everyone here is with the applicant.
Okay.
Or otherwise can be on.
Okay, great. So we'll go into confidential session now. Ms. Eckert, you have no redirects for Mr. Taylor, is that correct?
That is correct.
Okay. All right. Thank you for being here with us, Mr. Taylor. You can be excused. Would you like to call your next witness?
Yes, next we'll call Andrew Lyons.
Mr. Lyons, please turn on your camera, your microphone, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right. Please state your name and work address for the record.
Andrew Lyons, Lines. My business address is 200 South Wacker Drive, Chicago, Illinois.
Ms. Eckert, you may ask.
Mr. Lyons, were you identified as the witness for certain data responses in this case?
That's correct.
And did you also prepare a property valuation report for this application?
I did.
And are those the areas to which you were providing testimony today?
They are.
Mr. Chairman, we tender the witness.
Ms. Gosnell, any questions for Mr. Lyons?
Yes, there was a question deferred earlier with regard to the property valuation. And so you have your lengthy report, which I realize analyzes a lot of material, but specifically you had 10 examples that you had studied closely that I believe your company had been involved in. 8 were 500 acres or less, 2 were 1,000 acres with a maximum of 100 megawatts. And as you know, this one is 3,000 acres. So what I asked was, could you please give us a little more information on how those smaller projects how those valuations would transfer over to a larger project?
Sure, and that's a great question. One of the things I can't do is make up data. And the reality is that the much larger solar farms just haven't been constructed or operating long enough for us to extract specific data. However, we've studied over 25 different established solar installations in over 15 states, and in all the cases, no matter what the size or layout, we haven't identified any measurable and consistent negative differences between test sales or properties that are located immediately adjacent to the solar farms and control sales, which are comparable data points that are not located next to solar. And despite the size that you're talking about, no one adjacent house can view the entire project at one time. And so most homes that are immediately adjacent to solar farms typically will only look at 5 to 100 to 150 acres. Pretty hard to see 3,000 acres all at once. And so the proposed development area will be similar, where some adjacent homes may view a portion of the total facility, but not the entire site at once. And so the data we have does reflect how any one home that's near the project area would have a particular view of the proposed solar farm.
Did you detect any difference between properties of less than 5 acres and larger properties that were adjacent to or near these farms?
No. Again, we haven't found any consistent negative impact by any home that we examined, whether it's next to a small community solar project or a larger utility scale. And I'll note that we're continuing to track some of the larger installations. For example, in southwestern Ohio, there's a very large development. It's called Hillcrest Solar. And we continue to examine that one. It is operating. We haven't found any sales data of immediately adjacent property, but we have found data that's within a reasonable distance. And when we look at those sale prices, there doesn't seem to be any negative influence on those particular sales. And that is a operation that's a little bit closer in size to the proposed.
Thank you. No further questions.
Okay. Deputy Secretary Lyons, any questions?
No questions, Mr. Chairman.
Okay. Mr. Montgomery,
No questions, Mr. Chairman.
Vice Chair,
No questions.
Commissioner Butler,
No questions.
Just going off the last line of questions, Mr. Lyons, I get that you're looking, when you do these, whether it's a match pair or, whatever methodology you use, what you're looking at are actual sales, right, to some sort of comparison to a control. Has anybody, are you aware of whether you've done one or anybody else has done a study as to not what they're selling for, but whether it impacts the timeliness or ability to sell property? And I asked that from, your response there was about that none of the directly adjacent properties had been sold yet. But do you all, or has anybody actually studied whether or not properties that have been listed to sell or put up for sale or up for auction, whether it has affected their actual ability to sell, never mind at what price they sell?
We do track days on market, and so that is a bit of evidence. And so we do look at the total time on the market for any home that's immediately adjacent to solar. It does need to sell because you just never know if there's a particular home that's listed for market. It might be at a really crazy, very high price, and that's why it doesn't sell. So we do track sales and see how long they've been on market, and we compare those test area days on market to control area days on market, and we don't see that there is a difference.
Okay. Any difference or a meaningful difference?
Any difference. The times are consistent in every case.
Okay. And I guess my only additional question, especially land that has a passive use, farming, particularly land that forget row crops for a minute, but maybe that's used for livestock pasturing livestock. I'm just curious the prevalence in the studies that you've done. Has there been any meaningful difference between looking at properties that are adjacent or nearby that are residential in nature versus those that are, a land use that is passive in nature? Is it just that there's no meaningful impact to either, or is there even less of an impact? Well, I'll just say this: you put solar panels on a farm you put solar panels on land that's next to a farm that has cattle on it. I mean, I suspect my estimation would be that the cattle, it doesn't affect, they don't care one way or the other, right? It doesn't affect the ability of a person to run cattle on a farm. But I'm just curious if there's been a sort of a distinction or delineation made between land sales that include residences and those that are just used for passive purposes.
So we've done a number of studies analyzing land transactions that are next to solar farms. We've looked at sales of land that are for continued use for agriculture and ones that have a highest and best use for residential development. And we don't see that there's a meaningful difference. There's no difference. The sale rates are the same. I think generally, if you speak with anybody who's familiar with agricultural values, that those prices per acre are pretty consistent all the way around. And so we don't see that there is a difference for sales of land that might be used for residential development. In fact, we have one good example from the state of Indiana where a 10-acre parcel that had been used for row crops was acquired. It is immediately adjacent to an existing solar farm, and it was developed with a $450,000 house with a very large in-ground pool, and the house was 150 feet from the panels themselves. So we don't see that the solar panels are prohibiting the market from developing land to its highest and best use, even with regards to price.
Okay. And have you or anybody that you're aware of studied the impact, I guess I would say, or the ability to change outcomes related to mitigation of view shed and noise issues? And I ask, has anybody studied yet, is there a difference between facilities that are directly in the line of sight of homes, for instance, versus those that have employed some sort of view shed mitigation so that homes are not directly, or that the facilities are not directly viewable from homes? Has anybody gotten to that point yet in terms of how much they've drilled down on impacts?
I mean, I would say personally that we have. So, you know, again, in 25 different solar examples that we put together data, all of them may have slightly different view shade mitigation. Some of them only have a see-through fence. Some of them have, you know, sparse shrubbery and you know, very small trees. And others have, you know, pretty substantial, you know, mitigation with, you know, trees that are over 6 feet. Again, in all of those examples, we're not seeing that there's any negative or meaningful difference.
Okay. All right. I appreciate Mr. Lyons. Ms. Eckert, any redirect?
No redirect.
Okay. Thank you for being here with us today.
Anytime. Thank you.
Would you like to call your next witness, Ms. Eckert?
Yes, next we will call Brian Zoller.
Okay, Mr. Zoller, please turn on your camera, your microphone, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
Brian Zoller. My office address is 400 West Market Street, Louisville, Kentucky, 40202.
Okay. Ms. Eckert, you may ask.
Mr. Zoller, you are a member with the law firm of Frost Brown Todd, correct?
That's correct.
What areas of testimony are you prepared to provide here today?
I can speak to the property taxation of solar projects and industrial revenue bonds and the effect of those on property taxes.
No further questions. Mr. Chairman, we tender the witness.
Ms. Gosnell, any questions?
No.
Deputy Secretary Lyons?
No questions,
Mr. Montgomery?
No questions, Mr. Chair. I think my question was answered.
Okay. Vice Chair Covage?
No questions.
Commissioner Butler?
No questions.
All right. So, Mr. Zoller, right? Not Zoller?
Zoller, yes.
Yeah. All right. Well, I've been mispronouncing your name for 2 years. So, Mr. Zoller, let me ask about, did you hear my questions earlier to Ms. DeBleek?
I did, yes.
Okay. And are you aware of, or have you looked at the graph that I was specifically discussing with Ms. DeBleek earlier?
I pulled it up during the hearing and have reviewed it since, yes.
Okay. So let me just ask. Yeah, here it is. And the one I'm referring to, just so that we're clear, is at the bottom right-hand corner, Exhibit C, redacted, page 62 of 83.
I have that up on my computer screen, yes.
Okay. So it does, from an ordinary, I don't know how many of them have actually been signed. Well, let me take a step back. So are you aware of any instances in which a county has already entered into payment of a pilot agreement in preparation or anticipation of the applicant using IRBs to finance a solar project in Kentucky?
I'm not aware that any have actually been entered into. I'm aware that there have been forms of those agreements attached to inducement resolutions at the local level, but those typically do not get executed and entered into until the actual bonds are issued closer to the construction of the project.
So are you aware of like counties entering to something like an MOA or a resolution then indicating that they will do a pilot agreement and will help the applicant get industrial revenue bonds to finance their project?
Yes, I am.
And have those ordinarily laid out what the anticipated payment in lieu of tax amounts are?
Yes, those typically do. Those amounts are typically negotiated at the time the inducement resolution is presented to the fiscal court for approval.
Okay. So this, at the bottom right-hand corner of this, the $6.6 million tax revenue distribution projections,
yes.
Is it your understanding that assumes a pilot agreement and an industrial revenue bond to finance the project?
I'm basing that assumption on the comments from Mr. Leak earlier. I was not involved directly in the preparation of that pie chart.
Well, so let me ask this. You're generally aware of the tax impact of these projects.
Yes.
And if the project finances through a mechanism other than an industrial revenue bond, what portion, and I'm really asking for rough percentages here, just so that we can understand and the record be clear, what portion of those tax revenues are going to go to the state?
Okay, I'm trying to make sure I get your question answered correctly. So without an industrial revenue bond, about 90% of the projects are likely to be treated as manufacturing and only have state level taxes apply. So,
Is it safe to say the vast majority?
I would say the majority of the taxes on a project within IRB would be paid to the state and not to the local government.
Okay. And that designation as manufacturing, that's based on revenue guidance, right? Department of Revenue guidance?
That's statutory and has been that way for a long time.
Okay, great. So the majority would go to the state. And then if there is a change in, for instance, property taxes, would that just, is your understanding that would just be related to the removal, if the land is currently receiving an agricultural exemption for property taxes, that the primary change in property taxes would just be the removal of that exemption?
That would be one part of it, and then you'd also have additional local taxes on non-manufacturing equipment as part of the that are part of the project.
Okay, and that non-manufacturing, you said, would make up approximately, roughly 10 to 15% of the facilities?
I would say 5 to 10%. We're talking. There's still a lot of uncertainty on classification of the components with DOR because none of these are operational yet. But think about perhaps landscaping or fences or some monitoring equipment. There's a technical advice memorandum on point that maybe some of the wiring wouldn't be, maybe some of the transmission lines. So it's really dependent on how the project's laid out and also dependent on where these actually fall in the classification once we start filing returns on these.
Okay. Is there any ability for any of the local governments to receive tax revenue for like wages or occupational taxes for those individuals that help construct it or at least work in operating?
Yeah, I'm going to get a little, I believe that once these projects are operational, they're going to be taxed as public service companies, like a railroad, like a telecom, like airlines, and that's statutory. Public service companies are exempt from local occupational taxes, I believe.
And that's the Department of Revenue does all of that, right?
Correct.
Yeah. And they do that sort of on the behalf of local PVAs once it goes into service.
Correct.
Okay.
Just like the utilities that the Public Service Commission has jurisdiction over.
Right. As soon as the switch is flipped, and it starts producing, the DOR starts taxing it as a PSC.
Yeah.
Yep.
And that's a central taxation structure that to determine value of the asset base.
Okay. So without an IRB, are you aware of any payments that would, or any taxes that would specifically go to the school districts?
Again, it's going to, at the end of the day, it's going to be based on classification. There would be some non-manufacturing equipment that would generate local taxes.
Okay. And that would be, when you say local taxes, that would be split out between whether it's in a municipality, a county, or some that would go to.
Right. Just like any other asset in the county. You look at I've got the 2021 tax rate book. tangible personal property tax rate in Caldwell County is 44 cents per hundred of value.
Okay.
So
So the flip side of that, it's sort of a stark difference between whether there's an IRB and whether there's not an IRB, correct? As to where the tax, and I'm going to use tax revenue as being a pilot payment. I know it's redundant. A pilot payment being effectively what I'm saying is as taxes, a payment in lieu of taxes. But where the money goes that is related to taxes is starkly different between an IRB situation or a project that finances with an IRB versus one that does not, right?
I think there's the ability to significantly change the allocation of the total overall tax liability of the project from this, between the state and the local governments through an IRB.
Okay, and so there's I'm just taking this pie chart and going from it. There at least seems to be some portion assumed, going off Ms. DeBleek's testimony, that there's some portion of an increase in taxes that would still go to the state. Do you know if an IRB was entered into and there was let's say a significant, I don't know, I'm going to make up numbers here, but like $100,000 or $200,000 a year payment in lieu of tax per 100 megawatt. Let's say it's $500,000 for a 200 megawatt project. $500,000 a year goes to the county. I'm just making up numbers. Do you know what would, even if it's 100,000 or $1 million, do you know what would be anticipated that would still be taxed at the state level, regardless of what the pilot agreement shows?
Excuse me. When you enter when a local IRB is entered into, the project, the state level tax of that project changes a little bit. You get taxed on the leasehold interest, so the county leases the assets back to the project. So there's a tax on the leasehold interest there. And then there's also ability to reduce rates at the state level through approval through KEDFA of the local IRB. So it's really hard to say how much a reduction at the state level would be, because we're just there's several factors that go into that, and those aren't defined yet for this project.
Okay, and so, but I guess what I'm trying to make sure I understand is it still taxed as a public service company?
Yes.
Okay, so that portion, at least, I don't know what the rate will be if it changes for an IRB, but that whole portion through the Department of Revenue is still done the same regardless of whether there's an IRB or not?
It is.
Okay, and so is it just the difference then in the designation and the payment of taxes based off of whether or not the facilities or the portion of facilities are manufacturing equipment under state law?
Well, through the IRB, there is no local tax that would be applied to any part of the project that's financed through the IRB. The only local taxes that would be paid would be through the pilot.
Okay.
You're transferring ownership of those assets to the county and leased back, and they're exempt in the hands of the county.
So, and that's sort of the distinction I wanted to get to, is that though the tax that would have existed without the IRB on that manufacturing equipment is no longer applicable if there is an IRB because of that transaction you just described, right?
No, the local IRB does not exempt the property from state taxes.
Okay, so let me ask this. So it's for that tax that's applied because of its designation as manufacturing equipment, at that rate that it would be without the IRB, that does not change under an industrial revenue bond and pilot agreement?
Without an IRB, you're taxed on the full asset, the full value of the asset. Let's just do one panel to make it simple. So if it's a $100 panel in year one, it's going to be subject to state taxes at $100 of value. When you do a local IRB, you create a leasehold interest between the county and the project. At the state level, when that transaction happens, we believe, under current guidance, that you're only taxed on the leasehold value of that panel in year one. And there's a formula, and it's set forth in the property tax instructions. So if it's a 20-year, we're going back to a $100 panel. If you have a 20-year IRB, it's amortized over that. The leasehold of that, the lease of that panel is amortized over 20 years. So in year one, the lease is only for 1/20th of that panel, or $5. So the tax would only apply to $5. In year two, it'd be $10. In year three, it'd be $15 as you go over the life of that IRB. So you're going to reduce what the value that's being taxed by doing the local IRB, but it would still be subject to state taxes.
Okay, that is helpful. So if it's not through the IRB, that first year it's taxed at $100, right? In year two, is it taxed at its initial value or at a depreciated value without the IRB?
Without the IRB, there's a class life factor that's attached to the property tax returns, and it will go down over time based on how that asset gets allocated between 1 and 7 class lives. But would go down to probably 10% of the initial value of the asset. Again, I'm saying initial value and as the base, but remember when it goes to a public service company, it's not necessarily a cost-based determination for value. The Department of Revenue can value the assets of a public service company through several different mechanisms,
okay,
like sale, discounted cash flow. I think you're maybe aware of that from the utility side of things. But again, assuming that it's cost $100 in year one, and that will get depreciated over time. That $100 can change over time because of the public service company.
Okay, that's very helpful. And then just so that the record is clear, KEDFA, is that the Kentucky Economic Development Finance Authority?
Yes, it is.
Okay. And then just so that I'm clear, and it just, the graph really throws me here because I can't make heads or tails. That 3/4 of the money goes to the local school district. It is, if an IRB is entered into, is the amount that goes to the local school district for the most part controlled by that agreement?
It is. What again, as Mr. Bleak mentioned, it's only been early stage conversations with local government here, but what you've seen in other counties is that they're setting the pilot payment at a set amount per megawatt. And then the school district is typically made whole on what they would have received but for the pilot, and any difference would be then go to the county as negotiated.
Okay, that's helpful.
So
that could be the library, the school, whatever they agree to.
Correct. But there's a condition with with KEDFA. If they're going to approve an IRB at the state level for state level incentives, which is a rate reduction, one of the requirements for them to grant that discretionary award would be that the school board is made whole. And that's where that requirement gets pushed down to the local pilot.
Okay, is that a requirement applicable to industrial revenue bonds generally, or specific to industrial revenue bonds used for solar manufacturing equipment?
That would apply across the board, whether that would be for our distilleries or auto industry or any other industrial building that would qualify for an IRB.
Okay. And then finally, the county can agree to these IRBs, and if the county doesn't agree to it, the IRB can still be done through the state. Is that correct?
Technically, yes, that could be done.
And are you aware of any IRB that's been done through the state where the local county doesn't enter into the agreement?
I'm not aware of that.
Okay, and does even if they attempt to try to do it through the state, there has to be some sort of local support, is that your understanding?
I think it could be done without local support.
Okay, all right, well, interesting. I do appreciate it. I know this is very technical, and 2 years on, I'm still trying to figure it out, so I appreciate the
I
time.
am too.
Yeah, Ms. Ecker, do you have any redirect to Mr. Zoller?
No, we do not.
Okay, all right, thank you for being here today. So, Mr. Bentley, Ms. Eckert, I do know we will have some post-hearing data requests. I got a few of them written down. My expectation is that we'll need a few days to get those out. Trying to see here, I think I have.
Mr. Chairman, before, sorry to interrupt you, but out of an abundance of caution, we asked two of the witnesses discussed earlier to come back. Reviewing our notes on the break, we just wanted to make sure they were available. As Ms. Gosnell and Mr. Montgomery had mentioned, speaking with Mr. Hessler and Mr. Shirazi with the economic impact report. So I just wanted to bring your attention to that, if they're still available, if you need to speak with them.
Do you have any additional questions, Ms. Gosnell?
No, they've all been answered.
Okay. Mr. Montgomery, you don't have any additional questions, do you?
That's correct.
Okay. You're welcome to call any of the witnesses. You're going to get as many bites of the apple as you'd like, Ms. Eckert, but I don't think that we particularly need to ask any questions.
No, Mr. Chairman, we can release them. It was
Okay.
just out of an abundance of caution.
Okay, thank you. So it's my understanding that the statutory deadline in this, since it was extended pursuant to this hearing, is, I guess, a week and a half into April. April, I think, 10th is a Sunday, so April 11th is what we have. So we've got a little bit of time for post-hearing data requests. I don't know that we're in a rush like we have been. I think we can get post-hearing data requests entered by end of the day Friday. Is that right, Ms. Gosnell?
25th, yes.
Okay, so we can have the post-hearing data requests entered by this Friday, let's see here, February 25th. We ordinarily provide for 2 weeks. I don't know that it would indicate, anything was indicated to me that seemed to be unavailable. Deputy Secretary had a few questions for studies that it sounded like Ms. Pelicero indicated already exist, like the wetland delineation and a few others, and there were some questions about the church that you all may need a few days to get. But how about responses due by March the 11th, which would be 14 days from the last day they can be requested?
We do have the post-hearing meeting on the 8th.
We can change that.
Okay.
Change that. Will you all be able to, is that?
Yes, that schedule would work for us, Mr. Chairman.
Okay, so if you do need additional time, especially for the mapping and study around the church that Judge Curling indicated, feel free to request that additional time.
And Mr. Chairman, before we wrap up, one point of order or question for you. I'm assuming because we did not have any public comments before the hearing started that no one had signed up to speak?
That's correct.
Okay.
That's correct. We checked the line as of the beginning. Nobody had requested it up to at least 8:30, and there was nobody seeking it when we started a little after 9.
Thank you.
I will indicate anybody who is watching this live or watches it after the fact, at any time before submission of a case, we can take public comments on matters. They just need to either be mailed to the Public Service Commission at 211 Sauer Boulevard, Frankfort, Kentucky 40601, or they can be emailed to the Public Service Commission at psc.info@ky.gov. We just request that anybody who provides a public comment indicates their name, their address, and indicates the case number that they'd like those public comments to be entered into. In this matter, the case number is 2020-00244. Understanding, Mr. Bentley, that you all have a couple of outstanding petitions for confidentiality and your request for deviation that we've been addressing for the most part, through the final orders. Is there anything else that we need to take under submission before we adjourn today?
No, Mr. Chairman.
All right. Anything else we need to do, Ms. Gosnell, from your perspective?
No,
All right.
thank you.
So we will get those post-hearing data requests out by the end of the day Friday. Thank you. This hearing is adjourned.
Thank you all.